This is Environmental Law. We're into week 10 of term 3, 2019-2020. So we're really at the pointy end now. For those of you that haven't yet uploaded your second assessment, it is due tomorrow evening, I believe. Is that correct? Or no, Thursday evening. So a little while to go. And I do hope that everyone in the cohort can upload their work quickly, because I really would like to provide the feedback and the marks back to everyone as soon as I can. So please make a special effort to submit your work on time, and I'll get it back to you all as quickly as I can. Tonight we're dealing with the issue of criminal law. Now that's probably a misnomer, because what I intend to speak about and what's in the study guide is much wider than that. What you've probably gleaned is that the way I like to present environmental law, as indeed most of the units that I take, is wherever possible to make them practically orientated. Now, with environmental law, it's a little different in terms of the practical perspective, because at various times I'm moving between environmental law from a practical perspective as viewed by different parties. So that might be commerce and industry, that is developers, mining companies, farmers, things of that nature. Or it might be environmental law looked at from a practical perspective of regulators, local councils, state governments, enforcement agencies. Or it might be environmental law looked at from a practical perspective from the point of view of objectors, submitters to a proposal, interested parties, members of the public, Environmental Defender's Office. So tonight we're looking at environmental law primarily from the perspective of regulators, and a little more broadly than we've been discussing. It's not just local councils, state governments, enforcement agencies. It also to some degree involves police, the Queensland Police Service, for example, in Queensland, or the federal police in terms of environmental crime that is based on Commonwealth legislation. So we're looking at a fairly broad principle, but at the same time, we're looking at it from the perspective of the party that's under attack from the regulator or the Crown, as the case may be. So keep in mind that any examination question may be based around you're here to advise a regulator or an enforcement agency or a prosecutorial body, or it may be that based on tonight's material, the question is looking at criminal law and enforcement issues from the perspective of the person that's under attack. Now that might be a developer or mining company, a farmer, it might be an individual, it might be a range of people. So the heading is enforcement of environmental laws, remedies for regulators, or really that's what it should be in some ways. It is in fact environmental litigation, criminal law. I thought that was a catchier name to get people interested, rather than, it sounds a bit boring, enforcement remedies for regulators. But remedies for regulators is probably a better, more accurate name for what we're dealing with. So what are the remedies for regulators? Just to get you working your fingers and typing skills, or please feel free to unmute the microphone. What sort of remedies are available, do you think, for regulators? I know we've only got a small group, so I'm not picking on anyone. But if you'd like to contribute, that's great. Obviously, criminal law is one of them, but are there others?
There's injunctions.
Injunction, yes. Very good. Anything else?
Fines.
So, well, fines, yes. Well, fines are, yes, can be done through the criminal system, or they can be done administratively. So yes, very good. So there's a whole range of things other than simply criminal prosecution. And in many ways, criminal prosecution is a last resort for regulators. So a few good reasons for that. One of them is that it's probably better to deal with a problem quickly rather than to allow the problem to occur and then act in a reactive rather than proactive manner. So for criminal law prosecution, of course, it is by its very nature reactive, isn't it? We're responding to a crime that has already been committed. Why not get in and, as a regulator, deal with something proactively before the event occurs? And another thing about criminal law is that it's quite expensive in terms of prosecutions and also defence. From a prosecutorial perspective, the issue is that proof needs to be established beyond reasonable doubt. We all know that, don't we? As opposed to the civil burden, which is on the balance of probabilities, bearing in mind the Briginshaw standard, the Briginshaw test. Now, have I lost anyone with any of those brief statements? All good? All right. If you're watching this as a recorded session and you're not sure about Briginshaw or the standard of proof, just do a little bit of extra research before you move on. So within the broad range of remedies that are available for regulators, we certainly talk about criminal law prosecution. Now that prosecution is not usually conducted by the regulator that undertakes the investigation. So we have the dichotomy of the investigative roles and the prosecutorial roles. Can anyone tell me, who do you think is involved in, for example, the investigation of potential environmental law crimes?
Parks and Wildlife?
Yes.
Or whatever version in whatever state.
Whatever state, yes. Environmental protection agencies or whatever version in states. So government departments, essentially, that part of the executive that deals with primarily regulation and licensing, but also investigations. Now, that department would typically hand over a brief, and whilst it can be to the Queensland Police Service, for example, in Queensland, it may well go straight to the Director of Public Prosecutions. So when you're looking at criminal law from a regulatory or prosecutorial perspective, it's always wise to consider the issues of compliance and enforcement from the perspective of the DPP. We'll talk some about that tonight as well. As I said, tonight we're dealing with agencies that we haven't previously considered in this unit. So criminal law is more expensive and it's higher risk, and it comes late in the process. So whilst it can be extremely effective and have a very powerful deterrent effect, sometimes regulators choose not to go down that path. Now, of course, they can be subject to criticism, can't they? The criticism can come from the opposition, it can come from members of the public, and it can come from essentially saying, you know, people are going soft on crime, and there's this push, isn't there, this dynamic for sometimes political issues become involved, that it's seen to be doing something by prosecuting. But that may not be the best solution on all occasions. As we've identified, as we said, it may be damages or fines, injunctions, it might be compliance plans or notices that are given. It might be environmental audits that are undertaken, and that resolves issues before we start, and it makes it easier. Now, if we do get into the realm of criminal law, we need to consider that all offences are not the same. There are potentially different offences that apply in different circumstances. So we need to understand something about the classification of offences. And then, of course, we need to understand something about the defences that might be available to a person that is being charged. So some of those defences might be honest and reasonable mistake of fact, or it might be emergency, or it might be general environmental defences, and we'll talk more about those shortly. And of course, as a prosecutor or an investigating authority, you need to be mindful of the fact that every person who's a suspect has a privilege. What is that privilege, do you think, upon being confronted with the prospect of being charged. What's the privilege? Karen?
They're not obliged to speak to the police,
Yes.
not obliged to offer any evidence. It's up to the prosecuting side to prove the offence.
Excellent, yes. So there's that general right to remain silent, and there's a right against self-incrimination, or privilege against self-incrimination. So when it comes to convictions after a trial or on a plea of guilty, there is the sentencing process. So in courts, in the criminal context, we talk about different events in a court by reference to a shorthand. So a matter might be listed for a trial, or a matter might be listed for a hearing, a matter might be listed for a sentence. Usually a trial it's a rough designation, but a trial is usually in the higher courts before a jury. A hearing is usually in the magistrate's court, where there's a magistrate hearing the facts, making a decision about the facts and the law. And when we talk about a matter being listed for sentence, what we mean is that it's being listed for a sentence hearing, a plea of guilty, or a finding of guilt after a trial or hearing. Usually though, once the verdict comes in, the court, at least in Queensland, will usually go straight into the sentencing process, but you can have a separate sentence hearing. Now, there's a range of statutes that might be relevant in the context of environmental criminal law and prosecution. They're mentioned as part of the reference reading in the material, but there's a few more than in the study guide. So, of course, from a Commonwealth perspective, as always, the EPBCA, but also be mindful of the Crimes Act, Commonwealth. From a state perspective, there's the Environmental Protection Act, there's the Planning Act, there's the Building Act, but also be aware of the possible involvement of the Criminal Code, Queensland, which is 1899, and certainly the Penalties and Sentences Act, 1992. But also there might be some special rules. For example, the Planning and Environment Court rules of 2018 may have a bearing on the process of criminal prosecution. So I've mentioned that regulators look to bring criminal prosecution essentially as a last resort, and that makes sense for the reasons we've discussed. The onus of proof, the cost, the reactive nature of it. So regulators sometimes use administrative or civil tools as a way of managing compliance instead of that. And of course, the whole idea of criminal prosecution is really to punish, isn't it? It's a punitive jurisdiction. Now, it may have some component which is remedial, but usually it's to punish. And also it's to deter. So if a CEO notices that someone else who is also a CEO has just been sent to jail, it's a fairly strong deterrent, isn't it, on the CEO to do the right thing from an environmental law perspective. Now, one of the problems with environmental law is that it's essentially laid on the piece, and as we discussed, I think in week one, the common law really didn't have any basis for supporting the common law. It was not regarded as a separate area of practice. So environmental law crimes were for a long time not regarded as true criminal offences. You know, so you pollute a river, well, it's not a real crime. I mean, we think very differently now, but that wasn't the case. So you need to be mindful of that shift in emphasis, that change of paradigm, if you like, when considering particularly older cases in the context of environmental law. But most of the cases you deal with in environmental law are quite recent, quite modern. Now, can I ask a question? Do you know the difference between different categories of offences? Do we know the difference between indictable and summary, for example? Okay, and you know that indictable offences are primarily dealt with on indictment. Indictment it's essentially a form that's presented by a prosecutor in a higher court, in Queensland, the District Court or Supreme Court. It's provided to the judge, and it's in relation to that indictment that it's essentially what kickstarts the prosecution in the higher courts. But not every offence, only indictable offences can be dealt with on indictment. Having said that, there are exceptions. There are procedures for want of a better term, tagging along summary offences at the tail end of indictable offences in sentencing, so that we deal with all the matters, most serious and less serious at the same time. And there's another dynamic. In 2010 in Queensland, with the Moynihan reforms, many indictable offences were made such that they could or must be dealt with summarily. So now we have these strange hybrids of indictable offences that are dealt with summarily. Summarily meaning essentially in the magistrate's court before a magistrate. Oh, I hope that is not too confusing. If you really want to see the difference and how that works in practice, in Queensland you need to look at the criminal code and have a look at the way in which offences are categorised, and have a look at how the offences that are indictable are sometimes dealt with summarily. So sometimes there are other ways of categorising offences. It may be that the categorisation can be by reference to the elements of the offence or the extent of harm caused. So, for example, we'll see the difference between offences that relate to environmental harm, which is to a certain dollar value, as opposed to serious environmental harm, which is beyond a certain threshold of damage or potential damage. So if you're looking at this from a prosecutorial perspective, and you're trying to make a decision whether to prosecute or not, you need to understand the classification of the proposed offence, where it's dealt with. Is it a jury? Is it a judge? Or is it a magistrate? Because that might have a bearing on the cost and the time. It also might have a bearing on the time limits to bring the prosecution. Now, whilst generally speaking, there's no statute of limitations on prosecutors in bringing prosecutions for crime, there are exceptions, and those exceptions primarily relate to summary matters. So the less serious matters sometimes are subject to time constraints. In other words, you must bring the offence within a period of, say, 12 months or 2 years or 6 years. And the various statutes prescribe that time limits may apply in certain circumstances. So generally speaking, the indictable offences are more serious, the summary offences are less serious. That's in very simplistic terms. But of course, you need to consider the specific legislation. Now, it may be, and I think I've got this in the notes, if you look at section 494 of the Environmental Protection Act 1994 Queensland, you'll see that the issue of indictable and summary offences is dealt with in a very specific, to some degree unique way. An offence against the Act, the EPA, which provides for a maximum penalty of 2 years or more, is indictable. Very simple way of categorising it. If the maximum penalty is 5 years or more, it's not only indictable, but it's also a crime. And if it's 2 years up to 5 years, it's indictable, but it's a misdemeanor. This categorisation of crimes and misdemeanors goes way back, and in many ways, it doesn't matter in practice, other than it might have a bearing on issues in terms of which court deals with the matter and how it's dealt with. Now, under the EPA, anything that's less than 2 years maximum penalty is summary in nature. Okay, so that's the Environmental Protection Act. Now contrast that to the Vegetation Management Act in Queensland, which is also 1999, and every proceeding for an offence against that act must be taken summarily. Now in that act, there are time limits, section 68, you must institute the proceedings within 1 year of the commission of the offence or within 1 year after the offence comes to the complainant's knowledge. And then there are issues about which region you bring the offence within. So if it's a summary offence, it's got to be dealt with and the prosecution brought within that region. So if you're looking at a prosecution matter from the perspective of defence, and it's under the Vegetation Management Act, the first thing you should do is look at the time that the offence is said to have commenced and when it was prosecuted or came to their knowledge. And the second is, has it been brought in the correct jurisdiction? So an offence that's alleged to have occurred in Atherton should not be dealt with in Strathpine. For those of you that know your geography in Queensland, you'll know they're a long way apart. So keep that in mind. Now, as I often do, I'll bounce between the state and the Commonwealth. We'll have a look at the Commonwealth now. So no surprise, the key piece of legislation, the EPBCA. And the general rule that relates to the prosecution of environmental law matters is whether there has been significant impact on a matter of national environmental significance, in which case someone who engages in that activity is subject to very hefty fines potentially. So that's just an example of a breach of an environmental law that can give rise to criminal law sanctions. A good starting point to get a feel for this in relation to compliance and enforcement mechanisms is the Australian Government Department of Environment and Energy website, which deals specifically with some of the remedies available under the EPBCA. At the risk of the internet crashing, I will take you to this page just to show you, and I'll share the screen now. I do hope this works. You should have on the screen, does it show the Department of Environment and Energy? Is that what you see? It should be compliance and enforcement mechanisms. Okay, is that it? Yes, Lois?
Yeah.
Thank you. Great. Okay, so you'll see there that it talks about injunctions, environmental audits, criminal sanctions, remediation of environmental damage, enforceable undertakings, and then in relation to corporate bodies, the liability of executive officers and publishing contraventions or publicising contraventions. So a really good little summary in relation to each of those issues, which is expandable, and there is reference to case judgments, so an excellent resource. Now, while I'm sharing the screen, I'll take you to another resource, which is, in this instance, state-based in Queensland, and it's the Director's Guidelines for the Office of the Director of Public Prosecutions. Now, it's currently under review. The guidelines that I have on screen are the guidelines that are current, but as at 30 June 2016. And if you are involved in providing advice in relation to prosecutions, then you probably should consider the Director's Guidelines. And if you're involved in defence, you'll often look at the guidelines as well to see if there's any way that you can negotiate or you can use the guidelines to advantage your client generally. Now, of course, given that this is a general piece of prosecutorial material, it relates to a whole range of things, not just environmental law, as was the case in the first website that I showed you. But it's still worth considering in terms of, for example, number 3, expedition. Number 4, the decision to prosecute. Number 5, the decision to prosecute particular cases. All of those things might have a bearing. So I'll just stop the share now. So the DPP has this useful information, but you might also find useful information through council websites and other regulatory bodies such as the EPA might have some information. Now, any questions? I know I've been talking a lot, so thank you for your patience. You're doing well. All good? Now, you might have heard of private prosecutions. They're pretty rare, but still possible. So if there is an environmental crime and your client wants to do something about it, and your client is not a part of a regulatory body, then in some circumstances, have a look at the Act, in some circumstances, the citizen may be entitled to bring the environmental law prosecution, that is a criminal process. Usually, of course, it's the member of the public urging through perhaps a member of parliament prosecution to be laid. Usually the Crown is the prosecutor, but bear in mind that sometimes the legislation specifically says that it binds the Crown. It therefore follows that the Crown agencies can be criminally responsible for environmental crime, but I can't think of an example of that. Now, in the notes, you'll see in section 3.2 that I talk about the issue of intent, and where liability is established without a requirement to establish intent, penalties will generally be lower than for those offences where liability and intent are established. And have a look at that little graph, which talks about classification of an offence by reference to intent, where it distinguishes between mens rea, that is the guilty mind, strict liability, where if you did something, it doesn't matter that you didn't intend for it to occur, subject to some defences. Absolute liability, where there's no defences, it's strict liability on steroids. And note, corporations can be liable. Its corporate officers can be personally liable. So we see that now increasingly often. We see that in workplace legislation now, and we're starting to see that more in environmental legislation. Now, I mentioned earlier that when it comes to the EPA, there is a distinction between that which is material environmental harm and that which is serious environmental harm. So you need to consider sections 16 and 17 of the EPA respectively. When it comes to material environmental harm, note that the test is environmental harm that is not trivial or negligible in nature, extent or context, that causes actual or potential loss or damage. So I mentioned that the criminal law is reactive. It's not always strictly reactive. Sometimes it can be proactive in that it may be possible to mount a criminal law prosecution based on a breach of the obligation not to commit material environmental harm in relation to potential loss or potential damage to property. Another threshold for material environmental harm is that it results in costs more than the threshold amount, which when I checked last was $5,000, being incurred in taking appropriate action to prevent or minimise or rehabilitate and restore. Now, serious environmental harm is like that, but more. And we see a concept of irreversible harm. So it brings in the precautionary principle, doesn't it? So serious environmental harm is environmental harm other than environmental nuisance that is irreversible, of high impact or widespread, or caused to an area of high conservation value or special significance, such as the reef, or causes actual or potential loss or damage to an amount more than the threshold, which is $50,000, or results in costs of preventing or minimising or rehabilitation or restoring, which is beyond the $50,000. Okay, so keep those distinctions in mind if you're a regulatory body. So what are the defences? I mentioned a couple earlier. Honest and reasonable mistake of fact, section 24 of the Criminal Code. Have we done crime? Have you done criminal law? Was that with Lance? If it was, that would have been good. All right, so section 24 of the code, section 25, emergency, and there's a general one, general environmental duty. So this is a defence. Have a look at section 319 of the Environmental Protection Act 1994, where a person attempts to show that the harm occurred while lawfully conducting an activity, and in doing so, that person fulfilled their general environmental duty. So it's a very specialised defence that only applies in environmental law matters. Section 319 of the Environmental Protection Act 1994. That's the sort of thing that examiners like to put in an exam to see if you remember that defence. That may or may not be a hint. It's probably not a hint. It might be. Contempt hearings, have a look at the Planning Act, and before that, the Sustainable Planning Act. I think in the notes, did I include a case of Gold Coast City Council against Christofi? It's 2014 QPEC 62. It's a decision of His Honour Judge Everson. And it's unusual because it considered something we don't see every day, and that is an issue of contempt. Now, sometimes people get very stubborn, and sometimes people just don't follow court orders. It's as if they say, I don't care, I'm doing it anyway. So in Christofi's case, the council sought an order of the court that Mr. Christofi be punished for his contempt. And it was all on the basis that he'd contravened a previous order. Now, in 2013, His Honour Judge Rackerman imposed an order upon Mr. Christofi to the effect that he's to be restrained from using his house for any purpose other than a single detached semi-contained dwelling for one household. Under the planning laws, this should only be a single dwelling house. But what did he do? He ignored it, and he continued to rent out rooms in the house individually, pursuant to separate rooming agreements. So the council, in frustration, brought contempt proceedings. Pretty unusual. And in the context of explaining the powers, His Honour referred to section 129 of the District Court of Queensland Act, which states that a person is in contempt if that person, without lawful excuse, fails to comply with an order of the court. And it then goes on to say that a district court judge has the same power to punish a contempt as a Supreme Court judge. See, that brings in jurisdiction, doesn't it? Because bear in mind always, not just in environmental law, but the Supreme Court has inherent power, which is essentially unlimited to act as it sees fit. But other courts, the District Court doesn't, the Magistrates Court doesn't, the Planning and Environment Court doesn't. So in many ways, the power of the court to do things has to be vested upon that court through legislation. It's a little bit like delegated legislation, but in this instance, for contempt proceedings, the district court does have the same power to punish a contempt as Supreme Court. And Rule 930 of the Uniform Civil Procedure Rules states that if a court decides that the respondent has committed a contempt, and that person's an individual, then the court may punish the individual by making an order that might be made under the Penalties and Sentences Act 1992. So we have this really weird, convoluted way of making this contravention a criminal matter by virtue of Section 129 of the District Court Act, Rule 930 of the UCPR, and then the Penalties and Sentences Act. And of course, the Penalties and Sentences Act provides for the possibility of the imposition of imprisonment, doesn't it, as well as fines. So have a look at Section 44 of the Penalties and Sentences Act in that regard. Now, in that case of Christofi, His Honour relied on the observations of now High Court Justice Keane in Lade and Black, which is 2006 to QDR 531, where His Honour said, because the sanction for a contempt is inevitably to some extent punitive, all contempts must be proved beyond reasonable doubt. And that makes sense, doesn't it? And as to the degree of culpability required for finding a contempt, His Honour Justice Keane observed, this is at 552 of Lade and Black, because of the provisions of Rule 930 of the UCPR, there is a statutory basis for the imposition of a fine which does not require that it be established that the breach of the order was worse than casual, accidental, or unintentional. So in Christofi, Justice Everson found Mr. Christofi guilty of contempt, imposed a fine of $5,000 and ordered that the unlawful use of the house cease within 28 days and had to pay the prosecutor's costs. So that is the basis for imposing a punishment for contempt. Have a look at Rule 930. Also have a look at another case, BCC against Stapleton, 2006 QPEC at 73. I think it's in the notes. It is at 8.1. And you'll see there that there's reference to the way in which the Penalties and Sentences Act is applied, and look at subsection 9.1 and subsection 9.2. And one of those is that the sentence of imprisonment is a last resort. And when sentencing, you need to consider the maximum penalty and some other things that are important. Also, I've referred to Rockhampton City Regional Council against Dubois. And it's interesting because there's reference there to the case of Booth and Yardley, which is, we've already come across the name Booth, haven't we, in the context of these matters. In Booth and Yardley, Justice Wilson, who was Judge Wilson at the time, in fact now retired Justice Wilson, who was judge at the time, fined the respondent $5,000 for contempt in relation to an order to remove a power grid protecting an orchard from marauding squadrons of flying foxes. So this is the sort of the same thing as Booth and Bosworth. So in Booth, the fine imposed reflected a failure to comply with an order that had been made 2 years earlier. It's kind of an end of the Booth and Bosworth issue, when finally there was a contempt, and this is how the contempt was dealt with. And in Rockhampton and Dubois, the court made a note of the fact that penalties of imprisonment are a last resort, but His Honour Judge Searles said, I'm satisfied that there should be imprisonment and the defendant was imprisoned, but it was suspended after 1 month. All right, another thing is the execution of warrants. I refer to that in section 9 of the notes. There is the important decision of Chief Executive administering the Environmental Protection Act and another against Link Energy. That is a decision of the Court of Appeal 2015. You'll see the reference to that in the study guide, and there's it goes into a fairly detailed explanation of what happened there. But when we talk about the execution of warrants, we're really talking about the ability for prosecuting and regulatory authorities to go in and seize items. So it's a little bit like a Morava injunction, where in a civil context, there's an order to go in and seize items to protect them. In this instance, there's a warrant used very often in, of course, things like drug matters, but we're now talking about how these things can be used in enforcing environmental laws, aren't we? So under the Environmental Protection Act, there is the power for the department to exercise broad powers to seize computers, intellectual technology, equipment, etc., to investigate. Now, how does this happen in practice? Well, the case of Link tells us kind of the background and the methodology. So what happens is a magistrate issues a warrant in relation to the seizure. The warrants detail the circumstances in brief as to the basis upon which prosecution say that the respondents have offended. The investigation in that instance related to causing serious and material environmental harm and contravening the conditions of the company's environmental authority. The warrant executed, as it was executed, allowed it to be have effect on executive officers of the company, and the officers of the department were then able to download computer stored data onto devices in their possession. Now, the Supreme Court in 2014 in that case made a declaration that the seizure and the retention of the backup tapes was unlawful and ordered that they be returned. So that shows that warrants need to be executed in a very particular way, and the Supreme Court has the power to, if you like, make a declaration as to the legality of some of the actions that are undertaken. So that would be an application probably under section 590AA of the Criminal Code. So in other words, it didn't matter. So the issue for the Court of Appeal in this case was as to arguments as to whether the equipment constituted records. In other words, it didn't matter that the electronic records within the backup tapes and the information may not have been relevant. The argument put before the Court of Appeal was that the material could have been relevant. So that was the decision of the Court of Appeal in response to the earlier decision of the Supreme Court to make a declaration that the actions were unlawful. And again, it's another example of how you need to be willing to challenge the decisions that are made, because whether it's made by a magistrate, a judge, a justice, that's not necessarily going to be right, and you need to be mindful of that, which is the reason I wanted you to do the hypothetical appeal, to get you thinking proactively and not just meekly accepting that which is provided to you, even if it's from a court. I hope that makes sense. I'm getting a bit philosophical now. I know I'm moving quickly. Any questions, comments? All good? All right. Sentencing. Again, there's some good notes in your study guide about sentencing. Have a look at Section 9 of the Penalties and Sentences Act. That's critically important because it will set out in Section 1 the purposes for which sentence can be imposed, and in subsection 2 of Section 9, it talks about what the court must have regard to. Now, the court can have regard to other things, for example, the criminal history of the defendant, which I think is not mentioned in Section 9.2, oddly enough. But if you're looking at answering a question that relates to sentencing, you must introduce that. Now, bear in mind that in the Commonwealth jurisdiction, we're dealing with, to some degree, state laws in terms of process as well. Now, in the study guide, I think I've given you some examples of sentences. Yes, in 10.2, sentences that have been imposed, they can be quite substantial. For example, there's the Lady Annie Mines case, where the company was fined $500,000 and costs of $83,000. So that's the prosecutorial costs in that matter. They can be, as I said, they can be quite substantial. Then we have John Holland, Ross Prentice cases as examples as well. Have a look at the Department of Environment and Heritage Protection, which will provide some further detail in that regard. All right, so then we have one particular area, I won't dwell on it too much, but the prosecution of private building certifiers for granting a development permit without all necessary preliminary approvals being effective. Okay, now this is interesting because what we have here is the introduction of another piece of legislation that might have a bearing on environmental law issues. So Section 83 of the Building Act, Queensland, 1975, imposes general restrictions on the granting of building development approval. But it does provide in that section for the imposition of penalty units in circumstances where a private certifier grants a development approval prior to a time when all necessary preliminary approvals under the Planning Act have been effectively made. So, great deal of caution to be undertaken by private certifiers. Now, an example of where this went wrong was Gerhard and McNeil, 2015 QDC 270. This was a case that came before His Honour Judge Devereux, SC, and it was an appeal against a decision of a magistrate. So in this case, Mr. Gerhard granted a development application, or permit rather, for an accessible development for a building work on a house at Anley in Brisbane. And things went wrong. Mr. Gerhard was charged with granting the development approval without all the necessary preliminary approvals being effective. And if you look at His Honour Judge Devereux's decision, have a look at paragraph 4, because His Honour says the fundamental argument on appeal is that he cannot be so guilty because it cannot be proven beyond reasonable doubt that any preliminary approval was necessary. Now, by granting the development permit, Mr. Gerhard allowed his client, the homemaker, to demolish the existing dwelling and commence other works without the preliminary approval in place. But ultimately, His Honour held, after the argument, and you can read the development in the notes, that Mr. Gerhard had been properly convicted, and His Honour confirmed the orders of the learned magistrate in that case. So that's a pretty powerful message to private certifiers. Then in the notes, we talk about the issue of appealing against a sentence by a regulatory authority. And bear in mind, the general case, when we talk about appeals, is House against the King. It's 1936, 55 CLR 499. High Court decision. And the appeal courts won't necessarily just automatically replace their decision with the decision that was made, the decision was made with their decision. There's a threshold here before the court will intervene or disturb, as we call it, the decision of the lower court. The court must be satisfied that the sentence of the lower court is manifestly inadequate and the sentence imposed was not reasonably open to the originating court in all the circumstances of the case. So if you appeal and you say it should have been X instead of Y, the court will wonder whether Y was within the range, as we say. Now, it might be at the very top of the range, it might be at the very bottom of the range, but if it's within that range, even though the higher court might have imposed X instead of Y, it's not going to disturb Y. I hope that makes sense. In other words, it's only if it's outside the range of that which was adequate or reasonably open to the lower court that the higher court will become involved and intervene. All right, you've been really patient. Thank you very much. Just have a look at the final section in the study guide, or one of the final sections, environmental offences under the EPA. Have a look at section 437. And it provides for two separate pieces of causation. So section 437(1) provides that a person must not willfully and unlawfully cause serious environmental harm. And 437(2) provides that a person must not unlawfully cause serious environmental harm. So the first one is willfully and unlawfully. The second one is just unlawfully. No element of willfully, which means that we go back to that chart, mens rea, strict liability, absolute liability, and we try and categorise those sections in 437 of the EPA within that context of the type of offence and the issue of intent. Now do have a look at section 24(1) of the EPA, which provides that the Act does not limit any civil right or remedy that exists apart from the Act, whether at common law or otherwise. In other words, the imposition of a penalty for criminal law does not preclude a person from pursuing a civil remedy for damages. All right. Thank you very much. I'm just going to wrap up with something a little different now. If you've got your study guides in front of you, you can follow along with this, but we'll just have a quick straw poll. We'll have a look at the review questions and I'll ask you to answer A, B, or C to 4 questions and then we can call it a night. So are we right to go? You'll need to have your thinking caps on if you haven't already done this. All right, so what you'll do is for question 1, you'll just type in A or B or C. So listen carefully. In relation to what type of offending behaviour is it necessary for a prosecutor to establish intent? A, mens rea, B, strict liability, C, absolute liability. Getting some votes coming in. So the prosecutor needs to establish intent if the offending behaviour involves mens rea or strict liability or absolute liability. 3, 2, 1, time's up. I would go with answer A on that one. We ready for question 2? If you're watching this as a recorded session, please make sure that you give this some thought, even pause. For those of you in the live session, you haven't got that luxury. So question 2, What defence to criminal proceedings requires executive officers to demonstrate that they took reasonable steps to prevent environmental harm? A, honest and reasonable mistake of fact. B, emergency. C, due diligence. Defence, executive officers taking reasonable steps to prevent. We're getting some votes coming in. We're getting a lot of votes coming in now. And 3, 2, 1, we'll go with C, as was the vote with everyone. So thank you. Question 3, we're almost done. In Queensland, what act prescribes the basis for punishment for contempt? Is it the Environmental Protection Act? B, Penalties and Sentences Act? C, Criminal Code? The act that prescribes the basis for punishment for contempt. That's a little hint, the emphasis on the word. EPA, Penalties and Sentences, Criminal Code. Votes are coming in. Sarah, I think you've been first in with every vote.
Not the second one.
Not the second. Oh, did Karen beat you on that one?
Yeah.
Very good. So part of the purpose of this question is just to remind you that the criminal code deals with the offences, but not with the issue of how to penalise or punish. So in Queensland, the starting point is always the Penalties and Sentences Act. So we'll go with B for that one. Last one, question 4. To successfully appeal a decision with respect to penalty, what must a regulatory authority establish? A, the sentence was manifestly inadequate. B, the sentence imposed was not reasonably open to the court. Or C, both of those things. It's a race between you two, isn't it? All right, thank you. We're getting lots of votes coming in now. All correct, and the answer is C. Well, thank you very much for that little bit at the end in particular and your patience tonight. If you haven't submitted your work yet, you have, as I recall now, Thursday, the 30th at 11:45 p.m. for the second assessment. Please try to submit your work on time so that I can get the feedback and the results back to you as quickly as possible so you can start preparing for the take-home paper, which is on the Thursday, the 13th of February, due the next day. If you haven't already made arrangements to take that day off, please do so. If you prepare really well, given that I have given some hints already and will continue to give some more hints, you probably should be able to complete the task within 3 or 4 hours. But you could possibly do it quicker than that, or you may want to give yourself some more time. All right, any questions before we finish the session? All good? Okay, we'll see you next week. Thank you very much. Bye then.